Hello friends, good evening. This video we are going to talk about some important aspects of company law. This video will be useful for lawmakers, law students, or whoever trying to write law exams, law board exams, or LLB, LLM. So yeah, this is about company law, Companies Act 2013. I'll be talking more about Companies Act 2013 India. So the first concept is the characteristics of a company. A company is a special type of business that is formed according to the Companies Act 2013 in India. There are some important features that I already mentioned here. The first one is separate legal entity. Once a company is created, it is considered separate from the people who own it and run it. It can do things like buy properties and sign contracts in its own name. Okay, a company can buy a property and sign contracts in its own name. And the second characteristic is transferability of shares. The shares or ownership of the company can be easily transferred to someone else. That means from one person to another person, shares can easily be transferred. There are some rules, but generally it's a quite easy thing to do. And the third one is limited liability. The people who own shares in the company are called shareholders. So, shareholders are only responsible for the money they have invested. For example, they won't have to pay more than that if the company owes money. So, how much money they invested, they are responsible only for to that level. And the final one is capacity to sue and be sued. So, this is like the company can take legal actions against others and can also be taken to court in its own name. So, in the first point, I said company is a separate legal entity. Same time, it has some advantages. So, one of the advantages is it can be sue others, it can sue other people, or it can be sued. This is because the company is treated as a separate entity. So these features help a company to run efficiently and provide a good balance between flexibility and legal responsibility. Knowing these basic traits is important for anyone interested in corporate law or managing business. And the next one is ultra wires. So ultra wires. What is ultra wires? Ultra wires is a Latin term that means beyond the powers. So in company law, it refers to actions taken by a company that go beyond the powers given to it by its MOA, Memorandum of Association, or by the law. So let's talk about ultra wires a little bit. So ultra wires is nothing but, for example, a company registered to do real estate business. But if it is trying to acquire a contract for a different field, like software development, that is not allowed because the company in its memorandum of association it clearly mentioned the company's objective is to build real estate or build buildings or make layouts and sell them to the uh, consumers. But if the company is trying to do something beyond the power, beyond what it can do, that is called ultra wires. So there are some limitations. These are the limitations. The first one is object clause. So in memorandum of association, every company has to list the what the company is allowing to do. If the company does something that is not listed in memorandum of association, then it is considered ultra vires. It is not correct, and there's legal consequences. So there are actions will be taken when ultra vires are null and void. This means the company cannot enforce these actions, and others who deal with the company in these matters may also face problems. As I mentioned in the other example, if a company in its MOA, it's mentioned it will do real estate business only. But if it tries to enter into a contract with other person for something else other than real estate business, it is can attract legal consequences. And doctrine evaluation. So In the past, the ultra virus doctrine was strictly followed to protect shareholders and creditors. However, changes in the Companies Act 2013, especially from Section 23, have made it more flexible, like while still preventing misuse of the company's power. Let's talk about an example. Technova Limited is there is a company called Technova Limited. According to its Memorandum of Association MOA document, Technova's main job is to develop software. So Technova company, they wanted to develop the software. But if Technova company tries to enter into a contract to build houses, real estate business or building houses business, this action is beyond its allowed activities. So it is not allowed. Such a contract would be ultra virus and therefore void because building houses is not part of its approved business activities. Okay, thank you. And third thing in this video, third topic in this video is understanding dividends. So what is a dividend? Dividends are a part of company's profits given to its shareholders as a reward for their investment. For example, a company is there and some shareholders are also there. Company made some profits. So the company business is good and they made some profits. So they wanted to share their profits to all shareholders. So that is called dividend. So there are like two types of dividends, interim dividend and final dividends. So interim dividend is declared. Okay, these are paid before the company's annual agreement meeting and before the final AGM is nothing but an annual agreement, annual general meetings. Sorry,